You say 10 o'clock case?
I'm going to say is IRIZARRY versus Moore here? Are
I see Mr. McClellan. I saw Mr. Sherman too.
everybody here for that case?
Okay, both sides for
Both
IRIZARRY?
sides? All right, come on up.
Let's do it now then. We'll take a break after this one.
Each side will have 20 minutes, so whenever the appellant is ready, you may proceed.
May it please the court.
Okay.
Joseph Shaughnessy for the appellant, along with my co-counsel, Shannon Carlisle. And, Your Honors, I'd like to reserve 5 minutes for rebuttal, if possible.
Okay. We'll see if the little bell rings. If it doesn't, I'll try and remind you about 5
Okay, I have a clock, too, so I'll try
Okay.
and pay attention as well. Your Honors, we're here on the case of Lucas IRIZARRY v. Waste Management, and we'd ask that this court reverse the trial court's, the verdict of the trial court, and that's on the following bases. First, the appellant was deprived of a fair trial below for the appellee's failure to timely provide a updated CME report. The CME was performed by Dr. Steinfeld. He was an orthopedic examiner of the plaintiff. His testimony was that the plaintiff sustained a permanent injury in the accident and had a 5% impairment rating. The plaintiff had undergone surgery, and towards the end of his videotape deposition, he was asked a question by the defense on whether his opinion might change if the plaintiff's condition had improved. He said it could, but I'd have to see him again. Shortly before trial, the court permitted the defense to have a second orthopedic IME with Dr. Steinfeld, which the plaintiff did attend, and there was a request, a timely request for the CME report, the updated CME report from Dr. Steinfeld. There were 2 motions to compel. That report was never provided to the plaintiff, likely because the
doctor didn't testify about that either, did he?
The doctor did testify about he could change.
He said that, but the part about his reexamination never came into evidence, did it?
No, it didn't, but the prejudice of not having the updated CME report, Your Honors, respectfully, was that the testimony of his
it might
permanency
change
opinion.
his opinion if he saw him again.
Correct.
But the jury never knew that he saw him again, correct?
That is correct, but because he had that opinion there, it weakened his argument that the injury was permanent.
Well, I mean,
and
it'd
took
be
away.
speculation about
Right.
maybe. I mean, it seems like the judge just doesn't let the defense put in the fact that he had seen him again.
But he had seen him again, which
I know.
misled the jury.
But if the jury didn't hear about it, what difference does it make for our purposes?
Because the plaintiff was prejudiced because he did attend the updated IME. That portion of the deposition transcript was allowed to be played to the jury.
Part where he said, if I see him again, I might change my opinion? I mean, that's the gist of what he said.
Correct.
You're saying that's the error, because that came in. But I just don't see how, if the jury, so what? I mean,
Because, Your Honor, Dr. Steinfeld's testimony, we would have brought him to trial based upon his updated IME report if that IME report was still favorable. When we're not provided the report pursuant to the rules of civil procedure, as we were supposed to be provided the report, then we're limited in our ability to pursue and prosecute our case as the rules allow us. So that was with regard to the first CME doctor. With regard to the second CME doctor was Dr. Raskin. He was a radiologist that was hired by the defense.
Right.
His initial IME report was provided to my office. We read the report, realized he did not ever review the actual MRI films. He was missing information. Shortly before trial, the court extended discovery, so I was permitted to take Dr. Raskin's deposition. Dr. Raskin's deposition was taken. Once again, he locks in all of his opinions, relates that he did not rely upon the MRI films. He did not have them in his possession. Approximately 3 weeks later, when we were at trial on the first day, we're handed an updated IME report for Dr. Raskin that reveals that, hey, I've now had all this information in my possession, so our critical and central line of cross-examination showing that Dr. Raskin did not actually have materials that would have allowed him to reach the opinions he reached, considering he was a radiologist hired to review films and actually never reviewed them. It prevented us from effectively prosecuting our case. It was compounded then.
But what did the trial court do with that information?
The trial court permitted him to say that he did review the films, which was our central line of cross-examination. Had he reviewed the films from the very beginning, we could have taken other avenues to counter his testimony.
But she didn't let him say that, did you?
Oh, she let him say that he reviewed the films. What she would not allow him to do was actually, if we place the films into evidence,
Right.
she was going to permit him to then take the films, put them up on a view box, and parade in front of the jury as if he's...
Maybe I misunderstood. I thought she didn't let him say it, but said you couldn't use the argument that he didn't review the films. I thought that's what happened.
No, if we use the argument that he didn't review the films, he could say he actually saw the films. What he could not do, unless we placed the films into evidence, was parade them in front of the jury and say, here's the actual findings with the laser pointer and point out things on the MRI.
When were the IME reports, the updated IME reports, supposed to be delivered to you?
When they're completed. But
Which was when?
I don't know when it was. We had it the day of trial, the updated IME report. His
Yeah, no,
deposition was taken 3 weeks.
You're asserting that it was a discovery violation.
Yes, Your Honor.
You asserted that the first time you saw them was the day of trial. When should he have given those to you?
Well, I don't believe actually they should have been permitted to do an updated IME report after the discovery cutoff and provide him with additional materials and then give us the report on the day of trial.
I'm really having a tough time communicating.
The rule says...
When was the discovery cutoff then?
It was, I believe, September 30th, and the trial was in October.
September 30th?
Yes.
And the trial was in October?
Yes.
Okay, when in October?
October 13th, I believe.
So 2 weeks early.
2 or 3 weeks, yes, Your Honor. And that was where the prejudice, we believe, occurred, because on the day of trial, we're handed an updated IME report showing that he was provided additional materials, which prejudiced our ability to then cross-examine the doctor or retain someone ourselves if we knew he was going to actually look at the films. This case actually, or this court actually just handled a case, KENNETH v. Allen, that was similar to this. It was the same trial judge involving late disclosure of opinions of an expert. And in KENNETH, the trial judge allowed the expert to offer additional opinions that weren't contained in the report. The difference between our case, actually, and KENNETH is we went one step further than counsel in KENNETH. We actually deposed Dr. Raskin and locked in his opinions. We didn't just rely on his report. We relied on his report, and then we took his deposition, locked him in, relied on his deposition. And then we're given his updated report the actual day of trial. So we feel that the prejudice in KENNETH is actually exceeded in our incident case because of the manner in which the discovery was provided. Your Honor, the second basis, the plaintiff or the appellant would state that warrants reversal in the instant case pertains to defense counsel's injection of some claim of fraud on behalf of the plaintiff in jury selection. The defense argued that to the jury that is anyone familiar with people inflating claims, claiming something on their car was damaged or their home was damaged that wasn't actually damaged.
I guess we can't read Mr. Hightower's mind, but it would seem to me what he was getting at there might have been that your client had a pre-existing condition. I mean, that's what it struck me as. In other words, I mean, that was their defense, was it not? I mean, that he had this neck injury before and complained of pain in 1990.
It may have been, Your Honor.
I don't know. I mean, I can't understand what other context it could have been.
Well, if history is our guide, I think it was almost intentional injection of a claim of fraud.
Well, I mean, you could read it that way, too, I agree.
But in the reason I believe it was an intentional claim of fraud is because if you look at the trial transcript on page 291, Mr. Hightower's comment was, I said your client is guilty of fraud. So it wasn't a question just to explore the opinions of the
What
jury.
was the fraud he thought he was guilty of?
He never disclosed it. There was no evidence of fraud. There was not an iota of testimony that there was any fraudulent conduct on behalf of the plaintiff below. So we feel that at the earliest stages of the trial, to plant a seed of fraud caused the plaintiff's credibility into question, which then carried on throughout the trial with a multitude of other errors.
Does this relate to the Florida lottery comment?
There's a number of areas. The Florida lottery comment is one of them. There was also the comment that Mr. Hightower made with no evidence whatsoever. In fact, it was contrary to the evidence of his own pretrial statement that was submitted to the court that he believed the plaintiff was going to make a claim for damages of $150,000. The pretrial statement itself that he submitted said that our last demand was $390,000. So that was a false statement.
And they had offered $175,000?
Yes, they had actually offered more than he told the jury that we would be asking for, with no evidentiary basis whatsoever. He also made two references to the police report. The first reference was that the police officer filled out a short form, which meant there were no injuries. That was objected to. Mistrial motion was moved for and denied. And subsequent to that, he made a second mention of the police report that when questioning the plaintiff that he made no complaint of injuries to the officer. Statement's already out that the bell has been rung. Objected again. Objections once again sustained. And that was in the Thomas v. Gottlieb case. Prevents that type of behavior. Your Honor, it would be the plaintiff's position that the cumulative effect of all of the conduct of the defendant below, adding up to actually, in order to the jury verdict itself, which...
Counselor, you've completely ignored the voir dire questioning. Are you going to get to that or not?
The voir dire question?
Yeah.
I'm coming to that. Are we talking about the guilty and...
You're talking about the cumulative error at this point, and that you've left out that whole section, so I'm curious whether you're abandoning that.
No, I was not abandoning it, Your Honor.
The part about your car having transmit, that was in voir dire, wasn't it?
That was in voir dire.
Okay.
That question was in voir dire. There was also, and that was right close in time to some other comments made by defense counsel where he was misleading the jury on the burden of proof in a civil case and criminal case, where he used terms like guilty and innocent.
Well, the trial judge clarified that and said that's in a criminal case, this is a civil case and it doesn't apply. So the trial judge clarified
Then he continued to do it.
Right. The trial judge clarified we'd object, sustained.
Well, after that, I think what he was trying to say is that, you know, we're presumed innocent until proven guilty is basically what he was trying to say. I mean, I think he was obviously trying to, you know, interject a different standard here, but the trial judge clarified it. And then he said, well, we're presumed innocent until proven guilty, but you do have the burden of establishing negligence. So
correct, which is a different burden.
Well, I understand that, but, I mean, that's where he went after that. So, I mean, I have a hard time finding that was really harmful to
In and of itself, Your Honor, many of the things that he did may not rise to the level of wanting a new trial, but the cumulative effect of all of those errors. And I would respectfully submit that when you're told once by a court not to do something, and you're told the second time not to do something, and a third time, the rules have to have meaning. The court's authority and rulings have to have meaning. And to continue to ignore those rulings affects the actual verdict itself. In this case, what we had is these continued attacks on the credibility of the plaintiff led to some pre-deliberation on behalf of the jury, where they wrote a question saying that all of them were concerned about
What did he say about Morgan & Morgan's relationship with Dr. Hines?
He said that Morgan & Morgan paid Dr. Hines for a medical bill.
He paid for the surgery?
No, it was a one-time IME, but what that did is it injected that Morgan & Morgan was somehow paying off the doctor, and therefore they should not consider Dr. Hines' bill.
Oh, what they paid was the IME?
Correct. I
misunderstood
There
that.
was a one-time IME, or for the final narrative.
Dr. Hines
actually,
did,
Your Honor,
Dr. Hines did the surgery, correct?
Right, he did. Your Honor, it was actually for the final narrative. that he was talking about, which misled the jury.
His report.
Correct.
It's for the what? I didn't.
Report.
The final narrative, asking for his report, outlining his findings. So he's implying that Morgan & Morgan has
Isn't that
somehow paid for
customary?
That happens in all cases. It's not necessarily needed, but in order to do a demand
Well, I mean,
package,
if you ask the doctor to do that, you generally pay for it.
they always will do it, yes, Your Honor.
All right.
And then when you look, Your Honors, at the cumulative effect of all these errors, the jury's pre-deliberation, going to the credibility of the plaintiff itself, saying that they were concerned with some of the testimony. And significantly, the pre-deliberation occurred prior to us resting our case and prior to the plaintiff actually finishing his testimony and clarifying the difference between his...
So whose obligation was it to seek to interview the jurors?
It would have actually been, according to the case law, the court should have interviewed the jurors. We had moved for mistrial as the plaintiff. The defendant wanted to just continue on and see how the chips fell, and then the court could look at whether a mistrial was necessary.
Right, so if the court says, I'm not doing it, whose obligation is it then?
It would have been the plaintiff's obligation to move for jury interviews at that time.
And you all didn't do that?
We didn't do it, but we also did not know until the time of the hearing that there may have been a very valid basis for that, because the court actually had a conversation with one of the jurors afterwards about...
That juror said, I misused we, I meant me.
Right, it meant I.
Well,
It's rather...
Here's what's bothering me about this case, and maybe you can address it. I know that you wanted to reserve 5 minutes, but in any event, there was testimony by some of the expert witnesses, the doctors, that there was a pre-existing condition, and the jury awarded past medicals in this case only. And it seems to me that in situations where there's evidence that a pre-existing injury existed, and even though the jury found that the cause was 100% attributable to the defendant, that they will award past medicals and nothing in the future. And why isn't that just a reasonable interpretation of the evidence that the jury drew and, disregarded all these other errors you're complaining of and rendered a fair verdict?
Your Honor, actually there was no testimony that there was ever a pre-existing injury to Mr. IRIZARRY's neck, which is the area that he had the surgery.
Well, there
in
was,
this case.
I can go to the doctor's testimony because I just noted it here in my notes, but there was testimony that there was pre-existing injuries that were suffered by the plaintiff, right?
If I may, Your Honor, respectfully, the pre-existing injury was that he had a prior back surgery. There was never an injury to his neck.
Well,
which was
pre-existing degenerative condition of the spine and had a something bar and that would have been present before the accident, and that Dr. Richard Steinfeld testified that appellant's neck pain was related to the accident. However, on cross, he noted that his opinion was based off of appellant's subjective complaints and that his review of appellant's medical records for the 2 weeks following the accident showed full range of motion in appellant's neck. And both testified they were aware that he had surgery on his low back in 1993. So there was some testimony that there was a pre-existing condition that may have contributed to some of his problems, right?
With regard to his back. With regard to his neck, he had degenerative changes, but all of the doctors that actually examined him related those degenerative conditions to being a condition that would have been aggravated or exacerbated, causing the need for surgery.
They presented Dr. Raskin, who indicated the appellant had a pre-existing condition that could have contributed to the need for surgery.
Dr. Raskin was the doctor that did not
So,
review
there was some evidence that the jury could have considered to say, well, okay, we'll give him his past medicals, but nothing in the...
Did you get all your past medicals?
No, we did not.
You got some of them, 50-some thousand, right?
56, which there's no
56.
mathematical calculation that the jury could have arrived at to arrive at 56.
Was that a basis of their defense, that there was a pre-existing condition that contributed to his injuries?
Their basis of the defense, Dr. Raskin wasn't there to testify on whether it was related or caused by the accident. He solely was there to testify on whether he had sustained a permanent injury within a reasonable degree of medical probability. He was hired after Dr. Steinfeld's CME report came back, and that's the defendant's expert, saying that there was a permanent injury, a 5% impairment. He was then retained, not provided the MRIs, gave his report saying there wasn't a permanent injury, and then...
What was the total of your past medicals?
111,000.
111, so they gave you something like half, right?
A little more than half.
Okay, well, a little bit, approximately.
I'm sorry, Your Honor?
Approximately. It's approximately
About half.
About half,
half,
yes,
right.
Your Honor.
Okay.
Counsel, wasn't the other part of the defense that this was a very slight tap onto the car, that very little damage was done to the vehicle, and that these catastrophic injuries could not have occurred as a result of that?
One of their defenses is that it was a minor impact when the garbage truck backed into the SUV, yes. There was never really any testimony other than the photograph itself showing that there was a dent in the back of the truck. But there was no prior complaints of neck or treatment for his neck before this accident. And that was
he went like 3 weeks before he started complaining about his neck?
Well, he initially complained of his back, which was the area that had previously been injured long before this case, where he had the back surgery, which is his area of primacy of complaint. Once he received treatment to his back, he's realized my neck is also beginning to hurt, and then continually treated throughout this case.
Yeah, I'll give you a couple extra minutes if you want. And I'll also give you a couple extra minutes, too, so you'll have 22 minutes. So, okay.
Thank you, Your Honors.
All right.
Your Honor, Richard Sherman for the appellee. This was a totally expected verdict. It's trying to make a mountain out of a molehill. This was a minor tap. The jury saw the pictures. They're in the brief. There's just a minor little tap to the back of the car. To answer your question, the plaintiff, there was evidence the plaintiff had back pain, neck pain since 2002. Undisputed evidence he had arthritic and degenerative change in his neck at the time of the accident. He had no limitations.
Why would Mr. Hightower bring up the thing about the transmission in your car at Fort Dyer? What's the purpose of that? Suggesting fraud.
Now, all the comments of the fraud, that's I quote exactly the testimony, I mean, what they're talking about, the comment, and he never said the word fraud. The entire quote is on page 32.
Well, he says, does anybody feel it's okay to be dishonest in certain circumstances?
I'm sorry, what?
He said, does anybody feel it's okay to be dishonest in certain circumstances?
Yeah, that smells a whole lot
Yeah,
like fraud.
that's what he's talking about, this fraud right there.
All right, well, their cite, as far as the fraud, was he asked the jury questions about inflating claims. It's on page 287 of the transcript.
What's the purpose of that?
Well, and voir dire to find out how the jury feels about inflating claims. They say, do you know situations after the hurricane, if somebody inflated a claim or anything? They're trying to see if it's a proper question to find out if the jury thinks
So you think it's okay for him to suggest at the very outset of the case that the opposing party is committing a fraud?
Well, he did not. If he said fraud, maybe there'd be part of an issue, but he doesn't say that at all. It's on page 32.
About just being dishonest, that's different.
Pardon me?
He says being dishonest, so that's different.
Has anyone had a situation where they knew, let's say in a car accident, had damaged the car before the accident, damaged the bumper, engine wasn't running, or the transmission wasn't running?
He said, and I quoted, does anybody feel it's okay to be dishonest in certain circumstances, that it's okay to claim something like that? I mean, I'm quoting.
It just seems to me that's a proper question to see how the juries feel about inflating claims like the plaintiff.
How about trying to inflate the standard, the standard of proof? I mean, you know, you've got I read somewhere in the record that Mr. Hightower had something like 250 trials or whatever, that he's an experienced trial lawyer and he tries to inject a different standard of proof that applies in criminal cases as opposed to civil cases, and the judge has to tell him this is a civil case, not a criminal case, and then he interjects dishonesty and he talks about the Florida lottery, and I'm trying to sit here and discern how an experienced trial lawyer can throw all of that stuff into a trial and risk a reversal.
Well, I think they put in their objection and not what was said. Like the lottery comment, they mischaracterized it. And once again, he said, do you understand it's
Mr.
proper?
Sherman, why did he have to say that? Why did he say this is not lottery money? I mean, I think he made a correct statement about, follow the evidence, you compensate him for whatever. Then he says this is not lottery. Why would you say that? I mean, let me ask you, has Mr. Hightower done this before?
Yes, Your Honor. He's obviously a very But let me read the exact...
So he's done this before in cases?
Well, I mean, he's tried many cases before as well.
Has he ever been admonished for doing this kind of conduct in a case before?
He has one time about 10 years ago.
And that was Judge Schwartz's opinion?
Yes, Your Honor.
He did the same thing, it seems like.
No, he referred to evidence outside the record in that case. That was the whole basis of that.
But he suggested a fraud. He suggested a fraud in that case. He suggested that the plaintiff got together with the expert witness and came up with some cockamamie thing. I mean, it's the same. How do you
He didn't say the same. Look, may I read the lottery comment? Does everybody understand it's not... As everybody understands, it's fair and reasonable compensation, and it's not like, Florida lottery money or something like that. It's what the evidence shows.
When there's a legion of cases that say, don't say that.
Now, I disagree, Your Honor.
You disagree there's a legion of cases that say, don't mention the lottery?
Yes, Your Honor, I disagree. I tried to... One time I had that issue. The plaintiff attorney argued that, and I looked at it.
Let me ask you this. How does this court or courts like this stop this kind of conduct? How do we do that? I mean, this is totally improper what Mr. Hightower did. He has a history of doing it. He does it in this case, and it seemed to have worked. Why can't he just rely on the facts of the case? I mean, why would you interject all this stuff that he put in there?
I mean, you say he has a history of it. There's that one appellate case 10 years ago and had 250 trials.
I guess the public reprimand, too, that might have had something to do with it.
Yeah, that was 10 years ago.
The problem is you have an experienced trial lawyer. And I read somewhere in the record he's had something like 250 trials. We have an experienced trial lawyer that knows better than to interject issues like this into a case. And so that can lead some reasonable jurors to conclude that what he's trying to do is, in a sly way, interject issues that he knows are improper so that he can get an advantage over his opponent. That's basically the concern that a lot of reasonable judges would have when they read a record like this. Now, my problem is that, I think that there was some evidence of a pre-existing condition that the jury could have based its verdict on. They awarded maybe half of the past medicals, and there's a logical way to look at the verdict and say, well, maybe based on the evidence, the jury did what they thought was right and we shouldn't reverse it. But then you've got all these other issues thrown in, and it's also logical to assume that, well, maybe they should have given more based on the evidence and testimony, but for, issues like this that the attorney rejected into the case knowing they were wrong in the beginning.
Well, I think we have to look at the judge who was present at trial. I put the quote in, and she said to the counsel, I haven't agreed with you on most of these. I don't think anything that egregious has happened here. And then in the hearing on the post-trial motions, he didn't argue any of these, not a single one.
Let's talk about the evidence of the pre-existing condition and the evidence of the fact that this was just a very minor accident. So you, at the beginning, were alluding to some of the evidence and testimony that was presented, that he did have some evidence of neck pain in the past and that sort of thing.
Correct.
Talk about some of that for just a minute.
All right, yeah. It was a very minor tap. The pictures are here. The airbags did not even deploy. He had no limitations. He didn't miss any time from work. He didn't go to the ER that day. He went 4 days later, and the doctor found there was no pain in his neck, full use of it.
You're talking about the evidence of the pre-existing condition. The opponent says, well, really, that had to do with a back injury that was sometime in the past and really didn't have a lot to do with the neck. How do you respond to that?
Sir, I have in my notes that the evidence was that he had neck pain since 2002 and that he had definitely had the films taken right after showed long pre-existing arthritic and degenerative changes.
In his neck?
And the EMG of before showed no nerve damage to his neck.
Separate out a pre-existing condition. Don't you have to have medical testimony that says the accident caused this much and the pre-existing is this much? Otherwise, you get it all. In other words, what you're arguing is, look, this fellow had the eggshell skull. If he didn't have the eggshell skull, he wouldn't have been hurt at all, which is not a proper legal argument.
Well, the jury can...
There's nothing in this case where any doctor separated out what was pre-existing and what percentage disability might have been related to that, correct?
Your Honor, there's a million cases where the testimony is no at all related to pre-existing, and the jury gives nothing and it's affirmed. I mean, that's a totally common verdict if there's evidence is pre-existing. Go on, the EMG showed there's no nerve damage from this accident. He worked full-time, didn't miss a day at work, no limitations.
He had a 3-level cervical fusion, didn't he?
Well, the question is whether that was related to this accident or to degenerative changes. The jury apparently found it was.
He did have that, though, correct? That's
He
what
did
had.
have a neck surgery, yes, Your Honor.
Okay.
Jury, subtracted out the...
You see, the problem I'm having with this case, and I think it's the problem that's shared with Judge Sawai, is I think the outcome of the case, based on the evidence that was adduced, is probably a pretty reasonable outcome. But
yeah, sure.
When you end up with the kind of misbehavior that, whether the trial judge sustained it or not, it was wrong. It was just flat wrong.
You need to go tell Mr. Hightower.
And when you put on a website, quote,
Well, I think you're reading their objections. The judge who was present said there's nothing egregious happened. I haven't ruled with you. At the hearing on the post-trial motions,
an experienced trial lawyer doesn't interject issues like this into a trial and risk a reversal when you talk about lotteries and talking about the burden of proof in criminal cases and dishonesty and that sort of thing.
Plaintiff's trial attorneys lay seeds in the voir dire too.
When you start planting seeds like that, sometimes they germinate into a reversal.
Yeah.
And then
once again, preservation. None of this was raised in there.
Counselor, would you please stop talking for a minute?
I'm sorry?
I said, please stop talking for a minute.
I'm sorry.
Attached to the appellant's brief is a copy of Mr. Hightower's website that says, quote, "Our bad reputation can be yours."
That was about 10
years
ago.
Why in the world would we ever think that anything as innocent as suggesting that there was a beyond a reasonable doubt standard that had to be applied to the case would be an accident? Why would we ever assume that based on that sort of bragging about bad reputation? I'm really...
Well, I mean, that's 10 years ago. That was a former partnership who he hadn't been partners with. I mean, that was 10 years ago. How is it even relevant to bring up something somebody did or had on their website 10 years ago? Issues what they do today. I mean, it's just a smear campaign. Oh, look what he and his former partner did many years ago. Look at a lot of the ads that plaintiffs' attorneys put up and send around in their flyers. But that's not respectfully relevant in this trial. But we get to preservation of error. Once again, the judge who was present said none of this is egregious. I haven't ruled in your favor. At the hearing on the post-trial motions, they did not argue one word of this. I mean, if this was that egregious one, they argue it to the judge and show her. I mean, there's just no word. She was present, and she, believed it was a fair trial. I mean, and she was a fair judge. They're an aggressive trial attorney, and both sides, were good attorneys, and she fairly ruled in favor of each other. If you go through, I went through each individual objection and put the exact quote in there. Just respectfully, there's no prejudice or error. They haven't argued no reasonable person could have ruled as a trial judge did and denied the post-trial motion. So I think it's proper. There's no prejudicial reversible error. And they never moved for a curative instruction on anything, so it's just not preserved.
They moved for a mistrial, didn't they?
Huh?
They moved for a mistrial about 15 times.
Yeah. Every time anything, early on, they decided they didn't have a good jury, wanted a mistrial. But I mean, they didn't ever move for a curative instruction. Didn't bring it up in the post-trial motion. So, thank you.
Okay, thank you. Okay. You got 6 minutes and 50 seconds left, and I told you I gave you 2 extra minutes. So I just want to make...
8 minutes left.
Okay, I want to make sure that... I just want to make sure you understood that I gave you some extra time to be fair to him, because I'm giving him a couple extra minutes.
Okay. I thought we covered the issues. If you have
No. I just want to make sure I'm giving him a couple extra minutes. Okay. All right, I'll give you a couple extra minutes if you want to use them.
I'll be very brief.
All right, good.
Just to clarify a couple things with regard to Your Honor's questions about pre-existing conditions. The pre-existing condition was to his back. He did have one prior complaint, a neck complaint in 2002. That can be found at...
No, but
Raskin put it all on the pre-existing, correct?
Right.
He said he had no permanent injury, right? Raskin was the one that said...
Raskin did, correct.
Dr. Raskin, and he's the one that said it was all pre-existing.
Right, and that was before he ever saw an MRI.
Okay.
But on page 368 of the trial transcript, the complaint was not to his neck. As for a pre-existing complaint to his neck, it was to his ear, causing pain to radiate into his neck. And the medical records reflect that.
But the bottom line is, the jury heard all the evidence and the testimony. They heard how the accident happened. They heard the severity of the impact. They heard all of this, and they came back with a verdict that awarded you some past medicals, maybe half, somewhere around half of your past medicals. And so we need to take a look at this and say, well, did these errors in what the attorney did during the trial and some of the comments that he made cause the jury to give less than they should have when we have all this other evidence to consider? And that makes it kind of difficult for me to say that, well, maybe there's reversible error here when the jury heard all the evidence. And the trial judge seemed to be kind of put out with Mr. Mitnick, who was making all these objections towards the end, too. So
Yeah, I think that's a fair statement. We were forced to object to this type of behavior, and when you're forced to continually object to this type of behavior, it frustrates both the court, but...
So the issue is
for
that all this cumulative error constitute reversible error when, you've got a jury that may have... and a trial judge that didn't really believe that it constituted enough error to cause a mistrial. And we've got all this other evidence that the jury considered to say, well, we think this is a fair verdict, giving half the past medicals in light of, it may have been skimpy evidence, but evidence of pre-existing condition and the impact of the vehicles, which was obviously not very severe, and the fact that he waited a while to get medical treatment and that sort of thing. So. Seems to me like we've got to weigh all that and determine, well, was all this cumulative error sufficient to cause reversible error, and did it impact the trial?
Your Honor, respectfully, there were at least a couple times that the trial judge even recognized that Mr. Hightower's comments and actions weren't fair. She described it as not fair and inappropriate.
She said that when he interrupted Mr. Mitnick's final argument.
That was in closing, yes, Your Honor.
Yeah.
And, I guess at the end of the day, Your Honor, what we're asking a new trial for also is to stop this type of behavior. These antics continue, and we can speculate whether the jury took all these things into account, but we certainly know that the fraud comment was made, and with no evidence of it, and that was at page...
Okay, you've actually used 3 minutes, so I think each had a fair opportunity to present the case. All right, thank you both very much.